Welcome back to the Commercial Real Estate Show. I'm Michael Bull. Today we're talking about office tenant strategies. Please welcome my next guest. It's Matt Sauers. Matt is a partner with Morris, Manning, and Martin. They're a big law firm that has offices, I think, all around the Southeast. Very respected. And Matt, thanks for joining us here in Studio One today.
I'm happy to be here. Thanks for having me, Michael.
Well, Matt, one of the things that we've noticed from representing tenants in the Atlanta market here at Bull Realty is that sometimes the tenants don't realize how long this process can actually take. What are some examples of how long you've seen a lease negotiation take place? So from the time a letter of intent's agreed on between a landlord and tenant to actually get to an executed lease?
Well, I think your perception is exactly right. I have, in the last year and a half, seen at least 3 leases I can think of that took 5-6 months to go from LOI to actual execution.
Yeah, it can be crazy. I was doing a retail lease on 20,000 square feet that I think took us 7 months. I'm like, guys,
yeah.
It couldn't be this difficult. Well, tell us about some tips. If you had to give the top 3 tips, I know you probably have 100 tips for office tenants, but if you had to pinpoint the top 3, what are they for office tenants?
Well, I think the biggest one relates back to what we were just talking about, which is plan ahead adequately, and there's a number of ways that it impacts things across your lease, from economics to legal issues. You've got to ensure that you're going to have ample time to negotiate your lease, do your design and build out, and actually move into your new space we're seeing holdover situations very frequently these days, so it's not unusual. Obviously, you want to avoid it. You're typically paying 150 to 200% rent, and you also, as a tenant, expose yourself to different liability. But it's something that a lot of tenants don't think about on the front end. You're really concentrating on moving in and getting built out, and excited about new space and a new relationship, and don't want to think about sort of the back end and the implications that can have. But so really plan ahead, make sure you have sufficient time. I think about exit strategies as well, which I guess falls within planning ahead, and a number of provisions that relate to that, or like your transfer, assignment, subletting, subordination type provisions that are always important to think about. I think it's also, if you are a larger tenant who's doing sort of significant build out, you need to think about what third party players may need to be involved in terms of consents or input. On the leases that I was mentioning that have really had sort of a long lifespan, they all involved lenders, and we were in a position of trying to protect a tenant against the eventuality that its allowance wasn't going to be fully available. So we're talking about $3, $4, $5 million allowances, and having to reach agreements with the landlord's lenders to ensure that those allowances were going to be available for the tenant should there be a financial distress event on the landlord side.
Right. And then you talked about the importance of assignment and subleasing, and even today now we have rental desk, right, where people are coming in licensing a desk for a time. So how might the rights for a tenant, from a tenant's perspective, be important to a tenant to have favorable rights regarding subleasing and subletting?
Well, there's a couple things. I mean, one, it's a growth strategy to be able to assign or sublet. I mean, obviously the assignment provision can be in conjunction with a merger or sale or some sort of capital and growth event. It also can be an exit strategy if there's economic difficulties. A tenant wants to be able to sort of hit the eject button and make changes, reduce space, and or relocate if necessary.
Right, so good times or bad times, right?
That's right. It's both extremes.
Important.
Exactly. And we are seeing more and more of the desk licensing that you referenced, particularly with tech clients. That's an extremely important right for them to have. And I found landlords are pretty amenable to it. Landlord's biggest concern, obviously, a lot of them just say, we don't really want to know. Make sure you've got your insurance in place and you're not exceeding your occupancy rate, and we're okay.
Right. Yeah, well, that's interesting because we are seeing more of it. We had a guest on from Pivot Desk, and that's what they do in major cities around the country is help tenants that maybe they've leased too much space and they want to rent to some desk to some people. Maybe they're a business that helps them, right? That they're associated with them in some way. Yeah, I think we're going to keep seeing more of that. Well, let's talk about another question I think some tenants have is estoppel certificates, right? So if you're just driving down the road and tuned your radio, and as an office tenant, sometimes you're required to sign an estoppel, which is basically an agreement that says your lease is current, that the landlord doesn't owe you anything, and that you're current, and verifies the lease. My question comes to you, Matt, is that let's say that the tenant signs an estoppel, maybe for the office building owner to refinance a loan or maybe to sell the property, and there's a conflict, and the estoppel says one thing, the lease says something else. Which one controls?
Well, that's a situation we obviously try to avoid. It can create a lot of problems that I'm sure you can imagine. If an estoppel has language, which we typically try to get included, that says to the extent there's a conflict between the lease and the estoppel, the lease controls, then it's sort of no harm, no foul.
You try to get that in the estoppel. Do you also try to get it in the lease?
No, it's not really. I guess it depends if an estoppel form is attached to the lease, then yeah, we'd want to get it in there. But so often, estoppel provisions are going to say, even if they have a form attached, that it can be sort of substantially similar or in a form required by the landlord's lender or a prospective purchaser, that sort of thing, and they have categories of items that are required to be included.
Yeah.
And there's always and such other things as may be required or reasonably required, kind of the catch-all. But so if there is a clear error between information that's contained in an estoppel and the lease, first of all, it's unusual that will get past everybody who's reviewing it. So there's obviously
in the perfect world,
right, right, and if it's a smaller lease and a smaller estoppel, it's more likely to get overlooked.
Yeah.
If it's a larger tenant and this is a capital event with respect to which an estoppel is being delivered, then in all likelihood, if there's a difference in the termination date of the lease, then that's going to be noticed. But to the extent it's not a clear and manifest error and there is an inconsistency, the tenant is going to be stuck with what's in the estoppel.
Right. So the tenant needs to be careful when they're submitted an estoppel to make sure they're not signing something that's incorrect, or they maybe lose some rights that they had in the lease.
That's right. And this goes back to the same category of plan ahead, because so many times a tenant's required to deliver an estoppel within a prescribed period of time, and it may come to me 2 or 3 days before it's required to be delivered, and I, of course, will have revisions to it and send those to landlord's counsel, who then will send them to purchasers or lender's counsel, and before you know it, we're out of time, and the tenant's looking at a potential default situation.
Right, good point. And those do have time frames typically, because you can't hold up business. The tenant can't just sit on them and not respond to them. And I think it's interesting, as we're talking about tenant strategies, we talk about these clauses, some tenants don't realize what a tenant rep and a lawyer is doing for them until 3, 4, 5, 10 years down the lease. They think, oh, well, I'm glad I had a great tenant rep and a great lawyer. And we're going to have more information from a great lawyer for you right after this break. Stay with us. I'm Michael Bull. This is the Commercial Real Estate Show. We'll be right back. Xceligent, the resource professionals like CCIMs, CBRE, JLL, Colliers, and Bull Realty use for market intelligence. Commercial Search is the site to market and find available properties to buy, sell, or lease all over the country. Visit commercialsearch.com. Welcome back. I'm Michael Bull, and this is the Commercial Real Estate Show. I'm talking with Matt Sauers. He's a partner with Morris, Manning & Martin. We're talking about some important lease clauses, and we talked about for the break, Matt, that sometimes you don't know as a tenant how important some of this stuff is. until you need it down the road years later. What are some other clauses in the lease that tenants might want to be wary of or watch out for?
Well, it goes really beginning to end. One that we often see poorly drafted, certainly out of the gate and needing work, is the sort of lease and rent commencement provisions and how those tie in with completion of landlord work or tenant build out and rent commencement. A lot of times it's they sort of mysteriously don't align, and a tenant can be in a situation where it's required to start paying rent before it's really able to use and occupy the space.
Yeah.
So I know that's sort of fundamental, but
Right.
you'd be amazed how many times we see that in an initial lease draft.
And what's another clause or special stipulation that
Well, sort of going then from beginning to the very end is the holdover provision. As I mentioned earlier, this is something that I'm seeing, I'd say at least 75% of the time with my new leases now. I've got tenants who are facing holdover situations in their prior space because either things didn't go quite as planned, or they didn't allocate enough time for the new lease and space and build out. So that and that's problematic. Obviously, it's not ideal to be paying typically 150% of rent last due. But the biggest thing there is that it exposes tenants to other forms of liability, oftentimes consequential liability, which can be significant. So in negotiating holdover provisions, we always try to limit, well, we try to completely avoid consequential liability, but that's consequential damages. That's almost impossible to do. So we typically are able to get landlords to agree to waive consequential damages.
meaning, like, for example, maybe they lose a tenant that was waiting to get in?
Exactly.
Okay.
Exactly. That's right.
That
Loss
could-
of a lease.
Yeah, that could be huge.
Yep.
If you will, give us a few tips for a tenant that's concerned about operating cost rising a few years down the road. You know, they get in and have an estimate of what the rent's going to be, but most of these leases have rights where the landlord's passing along operating expenses through CAM. And what are some tips for a tenant there?
Well, a couple things. One is to provide sort of, it depends on what the operating expense definition is in the lease, but I typically can get a lengthy number of exclusions added to the operating expenses, so they're items that landlord can't pass through. Then,
And what's an example of a couple that you might be able to pull out of operating expenses that the tenant has to reimburse?
sure, anything that's otherwise reimbursed to a landlord. So for instance, if there is a casualty and a landlord is reimbursed with insurance proceeds, it can't then pass through its expenses in restoration or repair to the tenants.
How about capital improvements to the building?
Capital improvements we always try to exclude, and that really is on a case-by-case, market-by-market basis. A lot of times where we'll end up is they are amortized over their useful life.
Okay.
So tenant then pays its allocable share to the extent the useful life falls within the term.
Okay. And what are some ways to limit the increases in the expenses that the tenant's paying?
Sure. So we oftentimes will see caps of, it actually seems like the caps are increasing now, but in the last, I guess this cycle, I've seen 4 to 10% caps on controllable operating expenses on a year-to-year basis. One thing that tenants need to be really careful of, and this is often overlooked because it seems like if you get a 5% cap on controllables on a year-to-year basis, it's a victory, and it is, but landlords then typically will cram down that it's cumulative and compounding, so you can actually, if to the extent there's savings in early years in the term, those can be carried over and you can end up with a more than 5% increase and actually get a pretty big hit later on in the lease.
Yeah, that can be pretty big on one change of a word there, right?
Exactly. Yep. That's exactly right.
Well, what's a final tip you give our listeners to watch out for in their lease negotiations?
I guess another thing that often is problematic that we see is assignment subletting provisions. Again, don't always contemplate tenant future plans. And it's hard, nobody knows what the future holds, so we always try to make those as sort of broad and limit landlord approval rights. The last thing you want to do as a tenant is be in a position where you have a merger, consolidation, sale, major capital event, and you've got to go to your landlord to get consent in order to have a change of control in the company. That's obviously not an ideal situation.
Right, but the landlords, they want to have control. They want to know who's in the space. But I guess on an event of a sale or a merger, you're typically able to get that through, right?
Yeah, most of the time, and again, it depends on the language. If we are involved on the front end, then yeah, it's typically something we can handle.
Well, Matt, thanks for joining us in Studio One today.
It's my pleasure. Thank you, Michael.
Well, stay with us. We'll have more on office tenant strategies. I'm Michael Bull. This is the Commercial Real Estate Show. Stay with us. The Commercial Real Estate Show